you so much for joining us today. Because it is a highly litigated area, understanding the distinction between exempt and non-exempt employees is really critical here. You know, your exempt employees fall under generally one of these few categories. The top three are really the most used. But you may be opening up yourself to liability with your non-exempt employees. And that is basically anyone who doesn't fall under a specific exemption. All non-exempt employees are covered by state and federal wage and hour laws. To avoid paying overtime premiums, an employee must be exempt from overtime requirements of both state and federal. Basically, there's a few things. So you have to fall under one of those exemptions and then also meet the minimum salary test. Under California law, the most common exemptions requires employees to earn a minimum monthly salary of no less than 2 times the state minimum wage for full-time employment, and that salary must be a predetermined sum. The minimum amount may not be prorated for part-time work. And I think a lot of companies could have gotten in trouble over the last year if they took a full-time exempt employee who was making, let's say, 80K, dropped them down to half-time, now they're only paying 40K, but that puts them out of the exempt status. So be very cautious of that if you are doing that. The employees who do not qualify as exempt, you need to keep track of their time. And you have to keep accurate time records of hours worked by your non-exempt employees to comply with both state and federal laws. Basically, what you need to know here is that there is a new case that talked about rounding. And it basically says that a meal period of less than 30 minutes or taken after 5 hours of work creates a presumption that the meal period is non-compliant. And when a meal period is non-compliant, you're paying your employees a meal period penalty, which is 1 hour of pay. The court held that employers must provide that 1 hour of premium pay for such non-compliant meal periods, or provide evidence that the employee chose to voluntarily waive a compliant meal period.